said she thinks she got shingles.
Okay.
Yeah. So we'll see. Did we certify that I was reading the we agreed that I'm reading 40.1 and 40.5.
Yep.
All rise for the jury.
Remember, you all can always sit down, so if you come in, you can, I mean, I know you're waiting on them, but you can always have your seat. We are, standing for you. Okay, and you all maybe see it. I am going to read the jury instructions, and I want to draw your attention to one thing, ladies and gentlemen. I am now live streaming. I was not live streaming earlier, your jury selection. And that is because your place on the jury is, I don't make that public. So I do want you to assist me if there's a time during the trial that I have you leave the courtroom. What you see in the bottom screen is what they see on the live stream. So if I get ready to ask you to leave and then that camera is not pointed to the floor, the officers should bring it to my attention, but if we don't, just say, judge our faces. So it's my intention not to show your faces on YouTube. Okay. I am starting the jury instruction with 2.2. I will now explain some of the legal principles you will need to know and the procedure we will follow in this trial. A trial follows this procedure. First, the prosecutor makes an opening statement where she gives her theory about the case. The defendant's lawyer does not have to make an opening statement, but she may make an opening statement after the prosecutor makes hers, or she may wait until later. These statements are not evidence. I need the, are those the pads for the jury? I need the pads and the definitive. I forgot, I'm sorry.
Nope. You want me to hand them out now?
No, you can hand them out after I give my instructions, but they also need definitive. Next, the prosecutor presents her evidence. The prosecutor may call witnesses to testify and may show you exhibits like documents or objects. The defendant's lawyer has the right to cross-examine the prosecutor's witnesses. To prove the charges, the prosecutor must prove the following beyond a reasonable doubt. First, that the defendant was in a tavern, grocery store, business place, manufacturing establishment, street, lane, alley, or highway, or public building, at a park, and an election, a public meeting where people were lawfully assembled. Second, that the defendant intentionally engaged in conduct that threatened public safety, threatened violence to other persons, disrupted the peace and quiet of other persons, interfered with the ability of other persons to perform legal actions or duties. Those are options. They are not, they don't all have to be proven. The defendant must have intentionally engaged in conduct that went beyond stating his position or opinion or the mere expression of ideas. That the defendant was in a place open to the public. That the defendant was intoxicated. A person is intoxicated when he or she is mentally or physically impaired as a result of consuming an intoxicating substance, such as an alcoholic beverage or other substances. Third, that the defendant directly endangered the safety of another person or property, disrupted the peace and quiet of other persons, or interfered with the ability of other persons to perform actions or duties permitted by law. After the prosecutor has presented all of her evidence, the defendant's attorney may also offer evidence but does not have to. By law, the defendant does not have to prove his innocence or produce any evidence. If the defendant does call any witnesses, the prosecutor has the right to cross-examine them. The prosecutor may also call witnesses to contradict the testimony of the defense witnesses. After all of the evidence has been presented, the prosecutor and the defendant's lawyer will make their closing arguments. Like the opening statements, these are not evidence. They are only meant to help you understand the evidence and the way each side sees the case. You must base your verdict only on the evidence. My responsibilities as the judge in this trial are to make sure that the trial is run fairly and efficiently, to make decisions about the evidence, and to instruct you about the law that applies to this case. You must take the law as I give it to you. Nothing I say is meant to reflect my own opinions about the facts of the case. As jurors, you are the ones who will decide the case. Your responsibility as jurors is to decide what the facts of the case are. This is your job and no one else's. You must think about all of the evidence and all of the testimony, and then decide what each piece of evidence means and how important you think it is. This includes how much you believe what each witness said. What you decide about any fact in this case is final. When it is time for you to decide the case, you are only allowed to consider the evidence that was admitted in the case. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I tell you to consider as evidence. It is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness says. You are free to believe all, none, or a part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you have based on the race, gender, or national origin of the witness. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Does the witness seem to have a good memory? How does the witness look and act while testifying? Does the witness seem to be making an honest effort to tell the truth, or does the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias or prejudice or personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affect how the witness testifies? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all of the other evidence? The questions that the lawyers ask the witnesses are not evidence. Only the answers are evidence. You should not think something is true just because one of the lawyers asks questions that assumes or suggests that it is true. I may ask some of the witnesses questions myself. These questions are not meant to reflect my own opinion about the evidence. If I ask any questions, my only reason for doing so would be to ask about things that may not have been fully explored. During the trial, the lawyers may object to certain questions or statements made by other lawyers or witnesses. I will rule on these objections according to the law. My rulings for or against one side or the other are not meant to reflect my own opinions about the facts of the case. Sometimes the lawyers and I will have discussions out of your hearing. Like this morning, we went in the back hall. Please pay no attention to these interruptions or discussions. You may not discuss the case with anyone, including your family or friends. You must not even discuss it with other jurors until the time comes for you to decide the case. When it is time for you to decide the case, I will send you to the jury room for that purpose. Then you should decide the case Then you should discuss the case among yourselves, but only in the jury room and only when all of the jurors are present. When the trial is over, you may discuss the case with anyone. Although we do expect the case to conclude today, I'm gonna still read 2.13, recess. If I call a recess during the trial, I will either send you back to the jury room or allow you to leave the courtroom on your own and go about your business, but you must not discuss the case with anyone or let anyone discuss it with you or in your presence. If someone tries to do that, tell him or her to stop and explain that as a juror, you are not allowed to discuss the case. If he or she continues, leave and report the incident to me as soon as you return to court. You must not talk to the defendant, the lawyers, the witnesses, or my staff about anything at all, even if it has nothing to do with the case. It is very important that you only get information about the case in court when you are acting as the jury and when the defendant, the lawyers, and I are present. You may take notes during the trial if you wish, but of course you do not have to. If you do take notes, you should be careful that it does not distract you from paying attention to all of the evidence. When you go to the jury room to decide on your verdict, you may use your notes to help you remember what happened in the courtroom. If you take notes, do not let anyone except the other jurors see them during deliberations. You must turn them over to the court officers during recess. Your notes will not be examined by anyone, and when your jury service concludes, your notes will be collected and destroyed. You can see that we have chosen a jury of 8 after you have heard all of the evidence and all of my instructions. We will draw lots to decide which 2 of you will be dismissed in order to form a jury of 6. Possible penalty should not influence your decision. It is the duty of the judge to affix the penalty within the limits provided by law. I may give you more instructions during the trial, and at the conclusion of the trial, I will give you additional detailed instructions about the law in this case. You should consider all of my instructions as a connected series. Taken all together, they are the law that you must follow. After all of the evidence has been presented and the lawyers have given their arguments, you will go to the jury room to decide on your verdict. A verdict must be unanimous. That means that every juror must agree on it, and it must reflect the individual decision of each juror. It is important for you to keep an open mind and not make a decision about anything in this case until you go to the jury room to decide the case. The court has concluded its preliminary instructions. Are the people satisfied with the court's instructions?
The people are satisfied.
Is the defense satisfied with court instructions?
Defense is satisfied.
Are we ready for opening statements?
People are ready now.
Ladies and gentlemen, I am going to give you notepads now. If you take notes right now, well, I would rather you not take notes right now. But if you do write something down, make sure, you should have a number on the top of your jury, on the top of the pad. Is there a number? Make sure you have the correct number to your seat. They should have passed them out by numbers. So make sure your number coincides with your jury number. Okay? If you take notes right now, please mark it opening statement. Please remember that opening statements are not evidence. They are just a guide. And then if you take notes during closing argument, again, mark it closing argument. Ms. Ritter, you may proceed.
Thank you, Your Honor. Good afternoon, ladies and gentlemen. So, ladies and gentlemen, as I introduced myself earlier today, my name is Christina Ritter, and I represent the state of Michigan. Ladies and gentlemen, my job today is pretty straightforward. It's to prove beyond a reasonable doubt that on June 18th of 2023, officers were called to a residential street, Stouffville, in the city of Detroit, upon a malicious assault. When the officers got there, they came into contact with the defendant, Mr. John Clark. Now, ladies and gentlemen, I know during voir dire you all heard a lot about how a person looks when they're intoxicated, what a person will have to, what an officer or a reasonable person will have to prove to show that somebody has been drinking or been intoxicated. But ladies and gentlemen, what I'm going to ask you all is to listen to the evidence. We will hear from the testimony of Officer Law, who is one of the responding officers to the street, Stouffville, in the city of Detroit. And he's going to testify as to what happened when he arrived at his home and his observations of the defendant, Mr. Clark, when he arrived at his home. Ladies and gentlemen, the people also tend to prove through video the observations that Officer Law will testify to. And ladies and gentlemen, one thing I want you to keep in mind is that, like the judge said, anything that I say, since the counsel says or the court says, is not evidence. Okay? So anything I'm saying right now is not evidence. I'm asking you all to take a look at the evidence, and you all can, or you all said earlier in the year that you all will be able to be fair and impartial. And that's all I'm asking you guys to do. Look at the evidence and determine what the theory of the people case is. And that is that Mr. Clark was a resident, who was a family resident, who was outside on the public street, or public sidewalk, and just his demeanor and his disposition at the time he interacted with the officer. Now, ladies and gentlemen, while you're listening to the evidence, I also want you all to keep in mind that sometimes the law is set in place for public policy reasons. And when you look at the jury instructions, I want you to keep in mind that everybody in the neighborhood has a right to peace and quiet. Everybody in the neighborhood has a right to enjoy the peace and quiet and not be disturbed by any outside disturbance going on in the neighborhood. I also want you to keep in mind that the public policy reasons for some of these laws that are set in place is to protect the safety and the concerns of the people in the neighborhood, whether they be your next door neighbor or your family member or whoever. But I want you to keep in mind that there are public policy reasons for some of these laws that are set in place. So again, ladies and gentlemen, I'm asking you all to keep an open mind as you all stated that you want to voir dire and listen to the evidence and listen to the testimony. And once you all do that, you all will return the verdict of guilty. Count one of this ordinary person. Thank you.
Will the defense be making an opening at this time?
Yes.
Okay, you may.
Thank you, ladies and gentlemen, and for your patience and understanding and being a jury, because it is one of the most fundamental rights that we have as Americans. And I know a lot of people don't like it, but I cannot stress to you, I've been doing this for 27 years, how important it is for a fair and impartial jury panel. So thank you for everything. Trusting you and the answers that you gave in one year to be that, and do that. In regards to the people's case in chief, what you're going to hear, and in my opinion, I'm going to tell you what I believe the testimony is going to be that you're going to hear. And why I believe that testimony will be sufficient for you to find beyond a reasonable doubt that Mr. Clark is guilty of the charge as stated by specifically back in June, the one that's saying June last year, while people try to, well, you're going to hear testimony that the police were called to a residence. That police, when they arrived at the residence, they saw family members outside of the residence on the sidewalk in front of the house of the family residence. And Mr. Clark is a part of that family who owned that house. So in regards to it being a public place or anything besides sidewalk in front of your house, and most of you as employers know that that sidewalk is what you have to maintain, part of your residence, not a part of the public. So let's just be clear about that fact. And then we go to what the police or officer law actually observed. I don't know that a video will necessarily be played, or audio will not be played. I believe the testimony of Officer Law should be sufficient in what he observed, which is family members outside of family house talking, discussing whatever they're discussing, that based on what he had received in regards to going back home, that Mr. Clark was the object of someone's ire or irritation or something. That he walked with Mr. Clark, talked with Mr. Clark. I believe this is the one that walked and talked to Mr. Clark. And that there was no issues as far as Mr. Clark was concerned. That the officer did not see Mr. Clark acting in such a way to endanger himself or anyone else. That while they didn't see whatever the reason for the officers to appear, that officer didn't observe. He didn't see any disturbance that is a threat to Mr. Clark or anyone else. Further, I believe that the testimony is going to state that that officer did not give any sobriety tests. That officer did not take any breathalyzer or get any blood tests in regards to intoxication. And when I look at the jury instructions and hear the testimony, I do not believe beyond a reasonable doubt. And I thought the court was going to kind of go into beyond reasonable doubt, but beyond a reasonable doubt on each and every element as instructed in the jury instructions. I thank you for your attention and your dedication. I believe that you will find that Mr. Clark is not guilty.
All right. On behalf of the people,
This kind of grounds people like to other great people.
you may.
That, you know, people like to call off for him.
Okay.
Sorry.
Officer, step towards me and raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? All right, officer, you may be seated. Officer, I don't know if you can testify in court at 36 District Court, but the mic sticks up, and so just, adjust it where we can hear you. All right, you may proceed.
Thank you, Your Honor. Good afternoon, Officer Law.
Good afternoon.
Officer Law, can you state your name again for the record, please?
Officer Kalen Law,
Thank you, Officer Law. And Officer Law, where are you employed right now?
City of Detroit,
Okay. And what do you do for the city of Detroit?
police officer,
Okay, how long have you been employed as an officer for the city of Detroit?
9 months now.
Okay. And Officer Law, I want to take you back to on or about June 18th of 2023. You recall being dispatched to a street called Stokel
Yes, ma'am.
on that day?
Yes, ma'am.
And is that within the city of Detroit?
Yes, ma'am.
And is that the county of Wayne?
Yes.
Okay. And do you recall why you were dispatched to that location?
For felonious assault. and progress
Objection, Your Honor, that would be hearsay. You'd say that he had a run, but in regards to the definition or description of that run,
Counsel. As much as you can, no speaking objection. So the objection is to hearsay. Ms. River, what's your response?
That is not hearsay, Judge. I'm not asking for a statement made by the declarant out of court. I'm asking him why he was dispatched to that location.
Overruled.
Thank you. So again, I'm sorry, Officer Law, can you repeat let me repeat my question. Why were you dispatched to that location on Stokel Street?
I was dispatched there for a felonious assault and progress call.
Okay, and can you explain to the jury what a felonious assault?
Felonious assault is an assault that takes place where there's a weapon involved, potentially a firearm or a blunt object used against a person.
Okay, and, were you alone or were you with someone?
I had a partner that day.
Say that again.
I had a partner that day.
Okay, do you recall who your partner was?
Yes, Officer Warren,
Okay, and were you the driver or the passenger of the vehicle?
passenger.
Okay, and can you explain to the jury what you were wearing?
That day I had on a Class B uniform, button-up shirt with our name and badge numbers on them, and pants as I have on today.
Okay, and can you describe the vehicle that you were in?
I was in a fully marked scout vehicle, lights, sirens, emblem. All the time.
Okay, and, were you with anyone else when you came to that location?
We arrived first and then the supervisor arrived shortly after.
Okay, when you say we, who are you referring to?
Officer Warren.
Okay, and, can you describe to the jury what happened when you first approached the location?
When I first approached the location, I seen a large group of males holding back another male.
Okay, and where, if you recall, where was this large group, at when you came to that?
It was probably a house down from where the address of the location we were responding to.
Okay,
It was an empty fence, like a gated fence, but it would, another house would have been there.
okay, so as you're describing to the jury, it was in front of an open field?
Yes, with a fence, it was a fence right there blocking the field between us and the sidewalk.
Okay, and when you say open field, was there a house in there?
No, ma'am.
Okay, and did you approach, this crowd or did your partner approach this crowd?
I approached.
You did, okay, and what happened when you approached this crowd?
I obviously seen them holding back one male who seemed very irate.
I'm sorry.
Yeah. One male seemed very irate, and I made contact with him to see what was going on.
Okay, so let me just stop just one minute. Let's go back just a little bit. When you say a crowd, do you recall how many individuals were a part of this crowd?
No, ma'am.
Okay, the person that you said that you observed that this person was acting irate, is that your testimony?
Yes, ma'am.
Okay, and do you see that person in the courtroom, sir?
Yes, ma'am.
And can you point them out and tell me what they're wearing?
Green sweater, light complected male, brown boots.
Okay, judge made a record reflect identification of Mr. John Clark. The record reflect identification of Mr. Clark. Thank you. And what, if anything, did you observe about Mr. Clark? Can you explain it to the jury?
Yeah, like I said, he was visibly irate, and he just continuously other males that was around was like, he tripping. That's what they were.
objection, hearsay, Your Honor, and we would ask the officer.
Objection, hearsay, what's your response?
Judge, may I rephrase the question?
You may.
I'm sorry.
So we would ask for it to be stricken.
It's stricken.
may I proceed? Thank you. Officer Law, without telling me what anyone said, just your observations of what you saw, can you explain that to the jury, please?
Yeah, the man was visibly irate, and there was a bunch of yelling going back and forth between both parties and everyone involved.
Okay, and that's still within this crowd that you're describing?
Yes, ma'am.
Okay, and, is there anything else you observed about Mr. Clark when you approached him?
Yes, ma'am. I observed his shirt kind of pulled up in a holster on his right hip.
Okay, if you can stand up and kind of, demonstrate what you're demonstrating, please?
His shirt was pulled up like it was involved in a certain altercation. It's holstered inside the waistband. It was a holster that was in.
Okay, now, you can go ahead and sit down, I'm sorry. Now, when you say this holster was on his waistband, can you describe if it was inside the waist, band or outside?
That, I don't really remember whether it was inside or outside, but it was a holster that didn't have anything in it at the time.
Okay, you can see that from your observation?
Yes, ma'am.
Okay, so what did you do, without telling me what anyone said, what did you do after you observed?
After that, we pat him down
I would
to,
just ask, I'm sorry, Your Honor, I'm going to object next that the officer referred to himself as opposed to a him or someone else who's not present or may not be present testifying.
Yeah, Officer Law, just try your best. I know sometimes it's hard, but try your best to say what you did and not what collective was done.
yes, ma'am.
Thank you.
Yes, ma'am. I pat him down.
Okay, and did you, and let me go back. While you were patting Mr. Clark down, did you notice anything else about Mr. Clark's, physical appearance?
Slurred speech, stumbling in a manner, not really necessarily, I don't want to say stumbling, just unable to keep his balance and slurred speech while pointing.
Okay, and, what happened after you, pat down Mr. Clark? I'm sorry, after you patted down Mr. Clark?
From there, I detained him due to the nature of the run and him being described as the subject that we were responding to that location for. And from there, I don't really recall whether I put him in the vehicle immediately or left him outside the vehicle until I further investigated.
Thank you, and you did, according to your testimony, you're indicating that you did do further investigation in this case.
Yes, ma'am.
Okay, did you have, without telling me what was said, did you have any other discussions with, Mr. Clark personally? Did you have any discussions with Mr. Clark?
Yes, I did.
Okay, and can you describe, what you observed during those, I guess during that conversation with Mr. Clark? Without telling me what was said, can you describe, anything that you may have observed?
It was a bunch of bargaining.
Okay, and can you describe?
I'm sorry, I didn't hear that.
It was a bunch of bargaining. The conversation was bargaining.
Okay, and when you say bargaining, can you describe that to the jury? Without telling me what was said, can you describe what you mean by bargaining?
By bargaining, I mean, if you do this for me, I'll do this for you.
Okay.
Conversation.
Okay, and did you have any, without telling me what was said, did you have any other discussions with anybody else, part of this group or anyone during your investigation?
Yes.
Okay, and after those discussions, what happened?
From there, a call for a supervisor to make the location. The supervisor made the location, and Mr. Clark was put into the back of our scout.
Okay, and why did you call, if you recall, why did you call the supervisor to come to the location?
Due to the nature of the run, and not only that, the area that we were in, and there was another male that was down the street from the location who didn't have anything to do with it at all, who was causing a disturbance as well.
Okay. And did you observe anything else, going on while you're doing this investigation?
No, ma'am.
Okay. Judge, may I have a moment?
You may.
Thank you. And at this time, I would like to share my screen.
And at this time, Your Honor, we would object if the prosecutors attempted to show the video. There's been nothing in regards to impeachment or anything else that the video would be applicable at this point.
I don't understand the legal basis for your objection, so I'm gonna overrule it. You may share the screen.
If we could approach Your Honor.
Sure. Do you want to take down my screen? No. In the front, girl?
Yes. I think that's regular.
Now, proceed, Your Honor.
You may.
Thank you. Officer Lark, can you see the monitor in the courtroom?
Yes, ma'am.
Okay. And Officer Law, there's a still shot of a picture on that screen. You recognize that still shot?
Yes, ma'am, that's my right arm.
Say that again?
Yes, ma'am, that's my right arm.
Okay, I see two arms. Can you describe which arm is yours?
Right one with the tattoos on it.
Okay. And what is that a screenshot coming from? What still shot is that coming from?
From myself and my partner putting the subject into the back of our scout.
Okay, let me rephrase my question. What is that screenshot of?
Of the vehicle?
Okay, on that day, were you wearing any body worn camera?
Yes, ma'am.
Okay, and is this the pic of what your body worn camera was captured on that day?
Yes, ma'am.
Okay, and since you have turned that body, I'm so, let me jump back. Do you turn in your body worn camera to your supervisors at the end of your shifts or in a run?
Yes, ma'am. At the end of our shift, we return our cameras back into the armory.
Okay, now, since you have returned your cameras, from your point of view in the courtroom, has this been changed or altered in any way since you turned the camera?
No, ma'am.
Okay, Your Honor, at this time, if people will submit, people exhibit one into evidence.
And we would object, Your Honor, there has been no testimony or any other reason. It's cumulative at this point, and without more, just to say, well, I got a body camera, so I should be able to show it, is not appropriate to say, well,
Counsel, this is a wrong speaking objection.
and we would say that it's inadmissible at this time without more foundation.
Ms. Ritter, what is the response to the objection?
I'm sorry.
What's the response?
What was the legal basis? So what counsel was saying?
Lack of, I believe it's lack of foundation.
Okay, as to the legal basis of lack of foundation, Your Honor, I believe that Officer Law testified that that is his arm with the tattoos on there. He testified that he was wearing body.
I apologize, I don't think it was foundation. Ms. Taylor Coleman is saying that while that may be his body cam, you haven't shown a reason that is needed. She said it's cumulative. That was her cumulative. I apologize.
I'm sorry, Judge, the people's response would be that this shows that the testimony that Officer Law has given to the court is of the cooperating officer Law has testified to. So that's him wearing a body worn camera. I'm sorry, Judge, I don't mean to make a speaking objection, but. it's
Well, your
corroboration.
response can be, if I ask you for a response, but
It's
I just
corroboration.
want y'all to shorten up. Yeah. Hey, I'm sorry.
It's corroboration to the testimony from Officer Law.
I'll allow it.
Thank you.
Well, I apologize. I'll allow it subject to the previous, ruling by myself with respect to the body worn camera.
I'm clear.
Okay,
And at this time,
I'm sorry, Your Honor, corroboration, the response is corroboration of.
counsel, let's approach, because my ruling is that the body worn camera is admissible.
would you like me to take?
Yeah, so if there's. Come on, yes.
Thank you. Without the article, of course.
I'm sorry, Judge, now share my screen.
You may.
We would ask that it, for sake of corroboration, that it start at the beginning as opposed to at any middle point for the factual basis.
You may proceed.
Thank you, Your Honor. At this time, people like to play with you. Thank you.
Why do y'all make it on that, boss? Cause two zips. Okay, I am the IT tech for DPD. Yeah, this is what I showed you.
Right.
Headquarters, this, that.
Right.
Everything's good.
Right.
My
Good,
father's director. He's a fucking boss. Okay,
I
that's
understand
my
that.
father.
Okay.
We're good.
Okay.
Everything's clear.
No, boss. No, boss. Look. I got to do my job too.
Why are you then?
I got to let me talk to him. Let me talk to him.
Go over
I
there.
gotta do my job
Let
too.
me talk to him.
You got it.
Yeah.
I got to do my job too.
Yeah.
You already know how.
Yep, clear.
So what's going on? You said
Fucking acting an asshole.
huh?
Man, this is family issue.
Family stuff. I know how it go, but
this is my grandma's house. I lost her. My grandma dead.
I apologize.
On this,
Sorry to hear your
you
loss.
feel me? And it's Father's Day, and that's my father.
Happy Father's Day.
And that's what we going through.
So family issues.
So yeah. So I
kids and stuff.
all this. Yeah. Now I got to take care of that. I got more kids over here. And my son over here. Now everything got to get paid for me.
Right.
You understand me?
I feel you. That's why I wanted to talk to you first.
And at this time, now, the people are stopping the video at 4 minutes and 58 seconds, I'll stop sharing my screen. So, Officer Law, did you get an opportunity to view the video in court that was played?
Yes, ma'am.
Okay, and from your recollection, is that the testimony that you given in court today regarding your encounter with Mr. Clark?
Yes, ma'am.
Okay, and one last question, Officer Law. In the video, Mr. Clark, you and Mr. Clark were standing in front of this field. Do you remember, if you recall, where this field was opposed to the house? That was the question?
Yes, ma'am. That field was to the left of the house.
Okay, so you're
So
talking immediately, can you describe what you mean to the left of the house?
it was to the left of the house. So if I'm not mistaken, that field was on the south side of the address. So the house was facing west. That field was on the south side of the address.
Okay. May I have one over here? You may. No further questions, girl.
We would ask to be able to play video, from the beginning of the officer without audio. We would be easily enough to take the audio off.
Okay, my question.
Yeah. Before we show it, I just want to get prepped upon the screen. I will cross-examine. Thank you. Officer Law, at the time of this incident, you would have just been starting or graduating from the police academy.
Yes, ma'am.
How long have you actually been an officer?
June 18th, approximately somewhere between 2 to 3 weeks.
And when you appeared at this location, it was not for a drunken person or that was not the run, is that correct?
No, ma'am.
And you made a report about this incident, is that fair to say?
Yes, ma'am.
And that report, while it doesn't say everything that occurred, it said what you felt was important in regards to the incident that you observed, is that fair to say?
Can you elaborate on that, ma'am?
Ms. Ritter, can you stop sharing screen? Your report,
Yeah, can you rephrase the question for me, ma'am?
as you were instructed in the academy, you guys have to make a report, is that fair to say?
Yes, ma'am.
And that report should encompass the things that you felt were important about your police run, is that fair to say?
Yes, ma'am. Anything I observed?
And that's what you put in your report that day.
Yes, ma'am.
You had an opportunity to review that report before this trial, is that correct?
Yes, ma'am.
And nowhere in your report did you say that you observed Mr. Clark with slurred speech or an uneven gait or falling down or anything like that. Is that fair to say?
Yes, ma'am.
But here, some 9 months later, now you're coming in court. Now that's what you want people to believe you saw.
I'm just here to answer the questions that are asked him.
And you spoke with the prosecutor in regards to what this case is about, what your testimony should be. Is that fair to say?
I spoke to the prosecutor, yes, ma'am.
And you would agree with me that in your report, you stated that Mr. Clark said there were no problems, just a family dispute, correct?
Yes, ma'am.
You would agree with me that your report about the incident, and it was written very shortly after this incident occurred, correct?
Yes, ma'am. That
That
same,
9 months ago.
that same day, yes, ma'am.
Yeah, so in regards to your memory and what you saw and what you observed, your memory would have been better at the time that you wrote the report than some 9 months later about the details of this incident. Would you agree?
There are some things that I remember farther along the line.
You didn't supplement your report further along the line in regards to what you remember, is that fair to say?
Can you rephrase the question, ma'am?
You did not supplement, add to, increase, file a new report in regards to your memory being improved or things you may have forgot
No, ma'am.
back 9 months ago.
No, ma'am.
And you had never seen Mr. Clark before that day, is that correct?
Say it again, ma'am?
You had never seen Mr. Clark before that day.
No, ma'am.
You don't know him,
No,
don't interact with him,
no, ma'am.
don't know what his regular day is or anything like that.
No,
And
ma'am.
in regards to seeing him since that 9 months, you haven't, have you?
No, ma'am.
Do you remember everybody besides me? Who else would you pick out in regards to being the individual that you saw?
You saying, what's the question?
In regards to your identification, you don't know him, you haven't seen him in 9 months, and there's nobody else in this courtroom. So who else would you identify as Mr. Clark?
I vividly
That's
remember.
a speculation.
Repeat your answer.
I vividly remember Mr. Clark.
Nothing in your report describes Mr. Clark physically, is that correct? In regards to your vivid memory of
No.
Mr. Clark?
No, ma'am, nothing in the
There was
report.
nothing that stood out physically about him from any other black male that you've come across in regards to your work as a police officer.
No, ma'am, not in the report.
Yeah, okay. I'm really guessing. We never found that. I'm so sorry.
You make it too. Oh, I apologize, no, you can't, not yet, hold on. Okay, thank you. Thank you, thank you.
My last question was in regards to, you said you vividly remember Mr. Clark. However, in your report about things that were important, nothing is stated in regards to his physical vividness for you. Is that fair to say?
Yes, ma'am.
And you didn't observe any felonious assault in progress, is that correct?
Not upon arrival.
After your arrival, did you observe any?
No, ma'am. So that was the nature of the call. That doesn't necessarily mean that that actually had took place.
Right. But when you arrived, you didn't see anybody being threatened, is that correct?
No, I just seen a group of people holding back another male.
Did you understand my question?
Yes, ma'am.
And so I'm gonna ask you that specifically, I'm going to try to narrow my question so that you can answer
Yes, ma'am.
for what I asked.
Yes, ma'am.
Okay. And you don't recall about this crowd, is that correct?
Say it again.
This crowd, you don't recall the number.
No, ma'am.
The crowd, is it more than two, is it three, what?
Two or more.
Two or more is a crowd. And you don't know if all of those individuals were family members for a family Father's Day celebration, is that correct?
No, ma'am.
You don't know.
If they were our family at that moment, no, I do not.
You don't have any information that it was just a public crowd, is that correct?
No, ma'am.
That's not correct.
You saying it's a public, can you
That it was
repeat your question?
A group of just public people standing outside of this private residence.
It was just a group of males holding back another male.
You don't know if that
There was objection and action against it.
if that group of a number of males, two or more, was just a group of public people walking down a street or anything like that. Not a public event, like an event at a park where people gather to celebrate something. You don't know that to be those individuals, is that correct?
That question, like yes or no answer would sum up the true answer to that question, though, if I say yes or no to that.
You don't understand my question, is that?
No, I understand your question. However, the question, a yes or no answer to that wouldn't sum up the full answer of that question.
Can you say yes or no? You don't know if that crowd was from a public event, maybe just a public event in some way. You don't know if those individuals, two or more individuals, was from some public event. Is that correct?
No, those individuals knew the subject and were vividly yelling back at the people at that residence where the nature of the incident took place.
Do you understand my question? Because I didn't ask about anybody yelling or anything like that. I asked if you knew,
But can you rephrase the question, ma'am?
do you know if this was a public event at this home?
No,
And in regards to this open field, isn't it true that that open field was a part of the property owned?
Objection, Judge, that causes speculation.
I can ask anything else. Okay. Rephrase it. You don't know if that public field is, or the open field, as you said, belonged to the residence in which the two or more people were standing. Is that correct?
no, ma'am,
You don't
no,
know. So you don't know if it was part of a private residence. Is that correct?
the field?
Yes.
No, ma'am, I don't know.
But you didn't see Mr. Clark in the street when you approached, isn't that correct?
No, ma'am,
You saw him on the sidewalk.
yes, ma'am.
In front of his private residence, is that correct?
Unsure if that field was, you know, who the field belonged to, so he was on the sidewalk.
And nowhere in your report did you say that Mr. Clark was irate from 9 months ago, is that correct?
I apologize, counsel, repeat your question.
Nowhere in your report did you say that Mr. Clark was irate, isn't that correct?
Ma'am, can I refer back to my report?
Ma'am.
I didn't get to speak.
Oh, I from you.
I know she did,
I got this report from you.
from your desk.
Yeah.
I'm ready to play now. And may you repeat your question too?
Nowhere in your report does it say that Mr. Clark was irate, is that correct?
Not by my personal observation, no.
Thank you. And so it's not written in your report.
Family members that were at the location.
I'm sorry, my question was, it's not written in your report that Mr. Clark was irate, is that correct?
Family members that were spoken to
I'm
stated
not
that.
asking you, Officer
So
Long.
can you rephrase it for me then, ma'am?
Nowhere in your report 9 months ago did you write the words that Mr. Clark was irate, that you observed Mr.
No, ma'am.
Clark. Thank you. You didn't take any sobriety tests of Mr. Clark, is that correct?
No, ma'am, I didn't.
You did not take a breathalyzer test of Mr. Clark, is that correct?
No, ma'am, I did not.
You did not get a blood draw of Mr. Clark, is that correct?
No, ma'am, I did not.
If we could play something.
Counsel, before you play, I have, can you all approach about that? Come on, this side.
Sure. Okay. Oh, I'm sorry. You said off, audio is off. Oh, that is recorded.
Right, yes, okay. Okay, Ms. Ritter, you may share from the,
Oh, I'm sorry, there's one other statement before we share.
okay.
Nowhere in your report do you state that there was bargaining by Mr. Clark or anyone else. Is that correct?
No, ma'am.
Okay, you ready?
Ready.
Okay, Ms. Ritter.
Play here.
You may, yes, with no audio. Ladies and gentlemen, they're gonna play this video starting at the beginning. However, in the beginning, the court has already made a ruling that the conversation, I guess I would say, in the beginning of the video is not admissible. And so you can watch the beginning, but you can't hear it. Yeah, let's just play it from the beginning. How long, where did you start the video from? 4 minutes?
It was about 3 minutes and 30 minutes.
Okay, yeah, it's not that long to get to what you're trying to get to. It seems long because it's not that long. You all keep watching that, I'm sorry.
We can pause right there. Right here on your body cam, you see approximately 3 people. Would that be fair to say? Well, right here we see 2 people, but there was another individual on the other side. Do you recall seeing that?
Yes, ma'am.
And so when you say 2 or more as a crowd, that's a fair, accurate representation of what you saw on that day.
Yes, ma'am.
You continue playing. I'm sorry, can you see?
I'm sorry, this is the chair.
I know, you can, you might need to stand up, yes, sir. Yeah, and the plexiglass doesn't help, so. Pause it for a second, so. You're welcome. Okay, do you need to rewind it a little bit? Let me see. Okay, just rewind it a little bit.
And actually, stop, pause, I'm sorry. Actually, it's just those two that you walked up to in that part of your body cam. Is that fair to say? Did you see that?
It's another individual standing behind.
Stop. You see those two individuals?
Yes, ma'am.
And the person that's walking on the other side, is that your partner?
I can't see it.
Couldn't tell. Yes, please. You don't know who that other is.
So if it's as far as the original two, when I walked up, those, if there's another set of shoes, in fact, there are white shoes back there, and prior policy we can't do. So there was another individual standing.
Okay, so it was possibly three individuals. Is that fair to say?
I said, three upon, including the subject, or you saying two that was holding back. So
I'm sorry, I didn't see anybody holding anyone back in your body cam. Where did you observe someone holding someone back?
the male that's in front of our camera view right now,
You're saying he's holding them back?
if you can play the video back, you can't, I was gonna say.
Yeah, let's play.
I'm sorry, can the officer see? What he said?
I guess so.
Can you see?
Yeah.
Okay.
All this plexiglass still here, I don't know.
Right there, he's holding them back right there. And once more, he snatches away from the second individual.
You're saying that you can look at this and you're that,
Excuse me, did you want this?
yes, please. Thank you. You're saying that this looks to you like this individual is holding back that individual. Is that your statement today?
He's keeping the variable.
My question is, you're saying it's looking right here that you believe that this shows that this individual is holding back that individual.
Yes, ma'am.
If you can continue playing it. You stop. Thank you. And that individual walked around to come to you, the police officers, is that correct?
Yes.
Didn't run away. The individual you're stating is Mr. Carter. Didn't, you didn't see him hit anybody or anything like that. Is that fair to say?
No, ma'am.
Okay. But approached you, police officers, as you're doing your investigation. Is that fair to say?
Yes, ma'am.
Yes.
I guess, okay, yes. And you receive it. Counsel, I'm gonna interrupt you. Well, approach before I ask this question. So, but you go ahead. Well, I'm sorry. Come back one more second. Oh. You go ahead.
Finally, nowhere in your report did you state that you observed Mr. Clark endangering the safety of another person or property. Is that correct?
Yes, ma'am.
Nor did you observe him disturbing the peace and quiet of other persons. You didn't observe him because you don't know what was going on before you got there.
I didn't observe him disturbing the peace.
Thank you.
Ms. Ritter, you do have to redirect.
I do.
Okay, ladies and gentlemen, I'm trying my best to keep my word. I'm trying. So I have a question. Oh. All right, Ms. Ritter, redirect. Does anybody need water? Okay, let's get some water and then maybe let's go ahead and turn the fan on a little bit. Get a little breeze going of some sort. I don't know if we can move it closer to the jurors. Is there a plug over there by the jury box over there anywhere? Maybe we can put it over there. Madam Officer, somebody, I think two people need water.
Oh, sorry, I was trying to get your attention right there. Thank you.
All right. Okay, Ms. Ritter.
Thank you. Officer, I just have a couple of questions for you. So, at this point, you testified that you were out of the academy for about 2 or 3 weeks.
Yes, ma'am.
So your training and experience in the academy would, I guess, agree with me, it would still be fresh.
Yes, ma'am.
Okay. And during your time at the police academy, did you learn any training or experience with dealing with someone who is a firefighter?
Yes, ma'am.
Okay, and can you tell the jury what some of those things are that you learned?
I'm gonna object as to relevance, Your Honor, where stated specifically in regards to field sobriety, breathalyzer, or anything else he did not do. The relevance of what he learned in the academy in regards to interacting, especially where he acknowledged in his report, he didn't say anything. It's a long objection about Mr. Clark being intoxicated.
What's the legal basis for the objection?
Irrelevant.
Okay, Ms. Ritter. Overruled.
Go ahead, Mr. I'm sorry, Officer Law. Can you tell the jury what are some of the things you learned in the police academy regarding intoxicated or impaired individuals?
Based upon training, I was taught to look at slurred speech, inability to stay in balance. Also, the odor of intoxicants emitting from someone's breath. And obviously behaviors as far as erraticness and unable to stay on topic pertaining to a certain conversation.
Okay, and during your observation of Mr. Clark, did he indicate any of those signs to you?
Yes, ma'am.
Okay, and again, can you tell the jury what those signs were that you observed from Mr. Clark?
One of the signs were the slurred speech, the inability to remain standing in one place, and the inability to stay on topic of whatever the conversation was pertaining to.
Thank you. And based on your training and experience, when you observed those specific indicators, Mr. Clark, what did that indicate to you?
It indicated to me that alcohol was a factor.
Thank you. And going to, I think Sister Council asked the question of your initial response to the home. You testified it was for assault, correct?
Yes, ma'am.
And I think earlier in your testimony to me, you did indicate that you did do further investigation regarding your initial response to the home, correct?
Yes, ma'am.
Okay. And do you recall what you may have discovered during your initial investigation for this dispatch for police assault?
Objection, irrelevant, and after the point, actually not on point at all, but specifically in regards
I don't
to
understand, counsel. The basis of the objection is relevance.
relevance.
Ms. Ritter, what's your response?
That this was the dispatch call for police assault, so there's an investigation this call.
Sustain.
Thank you. Let me ask this, Officer Law, after, you had your interaction with Mr. Clark, did you talk to anyone else, without saying what they told you, did you talk to anyone else that was at the home?
Yes, ma'am.
Okay, and upon your discussion, without telling me what anyone said, upon your discussion, did that result of anything?
Yes, ma'am.
What did that result of?
Can we backtrack? Can you repeat the question again?
Right, so after your discussion with the person at the home, what did you conclude in your investigation? I'm sorry.
I concluded that an assault took place.
Okay, and how did you conclude that?
I'm going to object, Your Honor, especially in regards to not relevant, but also outside the scope of cross.
Sustain.
I have one more.
You may.
I have one more. I'm sorry.
Yes.
Okay, last question, Officer Law. So, when you initially arrived at the scene, you indicated that there were some individuals that was present with Mr. Clark, correct?
Yes, ma'am.
Okay, and based on your testimony, you said it was 2 or more within this crowd, correct?
Yes, ma'am.
Now, based off your observations, did it look like these people knew who Mr. Clark was?
Yes, ma'am.
Okay, and based on your observations, were there anyone else within that immediate area where Mr. Clark was?
Yes, ma'am.
Okay, and do you know, from your observation, or upon your investigation, I'm sorry, do you know who those individuals were? It's yes or no?
Yes, ma'am.
No further questions.
Nowhere in your report did you state that alcohol was a factor for Mr. Clark, is that correct?
Yes, ma'am.
That is correct.
Yes, ma'am.
Nowhere in your report, some 9 months ago, when you were just seeing this incident, did you state that? Is that statement you're making today?
In regards to,
Your report about the incident and the important things that you observed. Okay.
yes, ma'am.
Is there anything else?
Just very quickly. Now, Officer Law, when you made your report, you made your report based off what you were dispatched to the location, correct?
Yes, ma'am.
Now, based on, I guess, Detroit Police Department policy, are you required to make any supplemental reports to those reports?
Only if I found further information upon that investigation,
Upon what investigation?
upon the investigation of what we're, if any additional information could help or resolve some missing pieces to whatever the case may have been.
So your initial,
Yes, ma'am.
okay, nothing further.
All right. Thank you, Officer Law. You may step down.
Yes, ma'am.
I'm sorry.
All right. Anything further on behalf of the
I have one thing.
you may.
Nothing further from people have no further.
And the people rest.
The people who resident.
All right. Anything on behalf of the defense?
We have no witnesses, Your Honor.
Okay. Can you take the jury in the hallway just for a moment?
All rise to the jury.
They don't have to go to the jury room. Yeah, leave your notepads in your chair. They don't have to go to the jury room, but, just in the hall. No, go up there. Oh, the fan is right there. Okay, all right, you all may be seated with the exception of defense counsel and, the defendant. Mr. Clark? Sir, your lawyer has indicated that, defense rests. Did you heard her say that? And, Mr. Clark, that means that you have decided that you are not going to testify in this case? I need you to speak up. Correct? And Mr. Clark, do you understand that you have an absolute right to remain silent, but you also have a right to testify if you choose to? Do you understand?
Yes.
And do you also understand that, while you should consult with your lawyer about whether or not you should testify, the decision as to whether or not you will testify is yours and yours alone. Do you understand? In consultation with your lawyer, is it your personal decision not to testify?
Yes.
Has anyone threatened you in any way or promised you anything to get you to come to that decision? Thank you, sir. Okay, you can bring the jury back. You need to work?
Yes.
Okay.
Sorry.
That's okay.
Sorry to dance.
Where are the jurors standing as it relates to
The ladies back.
are they right there, Bryant?
The ladies who's at the other end of the on this side.
Okay, you can go ahead. Thank you. And then after she leaks out, you can bring in the jury, but.
Well, I have a motion before you bring it.
Well, then take them to the jury room if she has a motion. No, you go to the bathroom, you take them to the jury room.
just right.
Oh, my goodness, okay. All right, Ms. Ritter, your response?
So now, according
Oh, yes, you gotta speak up because of that fan.
I'm sorry, Judge. If the court is looking in light of the non-moving party, I'm gonna ask the court to deny the motion at this time. The people did present one witness, Officer Law. Officer Law indicated that he was dispatched for this assault run to this location on Slogan Street. Upon his arrival, he did come into encounter with Mr. Clark. At that time, Officer Law indicated that Mr. Clark showed signs of impairment and intoxication at that time. He was standing in front of the field that was next to the home in question. There was also testimony that there was a couple individuals holding Mr. Clark back, which seems to be that Mr. Clark was irate at the time that Officer Law approached the scene and addressed Mr. Clark. Based off of the testimony from the officer, Your Honor, I believe that looking at the jury instructions, the people have, with this one witness, met their verdict. But not only that, Judge, the people have given the court enough evidence. Oh, and there was a video played, I'm sorry, Your Honor. So with that being coupled with the fact that there was testimony from the officer about what happened when he arrived to the scene, the people believe that the people have enough evidence to survive the defense counsel's motion for a directed verdict. And at this time, Your Honor, I'm asking the court to deny the motion.
Any rebuttal?
Yes, Your Honor, specifically where the officer, so 9 months later, now wants the court and the jury to believe that this was about intoxication. He started off saying this was a felonious assault, but nowhere in his report at the time of the incident did he say anything about slurred speech. Did he say anything about inability to stand? Did he say anything at all about alcohol in regards to Mr. Clark? This is a case about public intoxication, disorderly conduct. For that to be true, besides whatever he was told in regards to his testimony for today, it lies in the basic reason and common sense that if that stuff was the truth, then why didn't he mention anything? Not just all of it, but any of them in regards to public intoxication. He cannot say that that street or the individuals that were present were a part of a public event, part of a but the elements in regards to a public event or disrupting a public event. He very clearly said he did not see Mr. Clark disrupt anybody. He very clearly said he did not see Mr. Clark be a harm to himself or anyone else. These are elements directly from the jury instructions that the people have met. Regardless of I'm coming to court now, those are elements that he never addressed, never substantiated. And therefore, the people, the court should grant our motion for directed verdict.
In reviewing a motion for directed verdict, court views the testimony and evidence in a light most favorable to the non-moving party, that being the people, and people would have to show the court that they have created a question of fact for the trier of fact. In a manner tried by the jury, some of the issues that counsel has raised are questions of fact for the trier of fact, whether the officer is being truthful today or whether his report is the best evidence of his truth. Those are questions of fact for the trier of fact, and in a manner tried by the jury, the court is not the trier of fact. I'm going to deny the motion for directed verdict, given the testimony and evidence in the light most favorable to the people, I believe they have, met their burden sufficient enough to sustain the motion. Anything further before I bring the jury back in?
No, thank you. Nothing further.
All right, they're bringing in the jury now.
I take a picture of the jury instruction for.
You can have a copy, you don't have to take. And that, you make me another copy. Council to the vote. Did you need all this? You have it, thank you. I'm not. Oh, I'm there. Yes, ready.
All rise for the jury.
All right, you may be seated. Are people ready for closing argument?
The people are ready.
All right, you ready?
Thank you.
Great.
Okay, ladies and gentlemen of the jury. As we come to the conclusion of this case, there are a couple of things I want to point out to you all regarding the testimony and the evidence that people have provided to you. Now, you all heard testimony from Officer Law. Officer Law testified that he was dispatched to a home on Stone Street in the city of Detroit. On his arrival, he came into contact with Mr. Clark. Now, his testimony indicated that Mr. Clark was outside with a couple of people coming to the inside. And it's very important that you pay attention to the details of that, ladies and gentlemen, because it's going to be important as to your instructions that you all will receive when you all deliver. Now, Officer Law came into contact with Mr. Clark, and Mr. Clark, as Officer Law testified, Mr. Clark has some slurred speech, he was unsteady with his feet, and there was an indication that there was some type of incident that happened to Mr. Clark and the individuals that were outside. Now, ladies and gentlemen, not only did you hear the testimony from Officer Law, but you all had an opportunity to review the video that was played in court, labeled as People's Exhibit 1. And in the video, as Officer Clark stated, I keep saying Officer Clark, Officer Law stated that he came in contact with Mr. Clark. And when he came in contact, you all saw the video, and you all heard the audio, and you all saw the signs of this occupation in Mr. Clark. Now, ladies and gentlemen, as I stated before, nothing I say to you is evidence. All of the evidence that the people have for this case have been given to you, the testimony and the video. What I do want you to do is take that evidence and apply it to the jury. And ladies and gentlemen, it's simple. This is not a trick case, it's a straightforward case. And once you apply those elements to the evidence that you heard from the Officer Law, and the evidence that you saw and heard from the video, the people believe that you all will come back with a guilty verdict of count one disorderly person. Thank you.
Are we happy? Thank you.
Thank you, ladies and gentlemen, and I'm glad that we have completed the testimony for today. Now it is in your hands as the triers of fact. The trier of law, you guys are the trier of fact. And the facts that you guys get to make a determination on is essentially the credibility of that officer. And while we did see the video, recall what I asked you in voir dire. Is there something more in regards to intoxication? Hearing someone you don't know, you have no idea in regards to the level or the intoxication. Officer Law said, I observed slurred speech. I asked you as a new officer to make reports about things that are important or relevant. Anywhere in your report, right after the incident, did you write anything about slurred speech? No. But after talking to the prosecutor, you made aware of what the allegations now are. Oh, I'm coming 9 months later and says, that's what I saw. If you saw it, why would you write it? Why would you address it? Well, not only did I see that then, but you don't know Mr. Clark. So you don't know how he talks regularly. You don't know if he has a discussion. You don't know what is going on with him. And you don't know. In regards to his inability to stand. I didn't see that. But more importantly, in regards to the officer's report, because really, factually, that's what we have to go on. I can come into court 2 years later and tell you the moon is green and I eat cheese off of it. But 2 years prior, when you asked me about the moon, and I have to make a report about it, what are we gonna look at for the veracity of what occurred? What happened at that time? Was there anything stopping Officer Law from updating his report to these facts that for whatever reason, back in June of 2023, he didn't see it wasn't important, it wasn't of note? Let's think about, he didn't say anything about slurred speech. He didn't say anything about inability to stand. He didn't say anything about staying on topic. He didn't say anything about being a threat to anyone, harming anyone, including himself. He did not say that Mr. Cousins is going to be this of any individual. If it occurred, even in your investigation, while you're looking at everything or anything else, why wouldn't you mention the 9 months later, now that it's what this case is supposedly is about now? Oh yeah, I remember now. And let's just be honest. I don't know about any of you guys, but in regards to my memory, if I don't take notes, I might not remember yesterday. So how do we come in 9 months later and have just almighty clarity about things that you didn't write down? Hopefully address. The public policy and all that, that's great and wonderful, but bottom line is there are elements that people have to prove. One of the elements is that the defendant was in a tavern, grocery store, business place, manufacturing establishment, street, lane, alley, highway, or public building, on a sidewalk. At a park, election, public meeting, where people are lawfully exempt. Private residence. He doesn't know if that field is part of that private residence. Secondly, that the defendant intentionally engaged in conduct that threatened public safety Violence to others, disrupted the peace, quiet of other persons present, interfered with the ability of other persons to perform legal actions or duties. You don't know if the person that called police had a problem with Mr. Clark, because Mr. Clark did something wrong. Had an issue with that individual, and they just wanted him wrong. You don't know, because you don't have that testimony, and you don't get to guess. You don't get to say, well, I believe based on A and Q and L, that ABC happened. You don't get to do that, because those are facts, it's not emotions. You get to make a determination about the facts. You do that based on the officer's response, based on the little bit of videos. He said it was a crowd of 2 or more. That he says was being held back, but yet, if he's being so disruptive and so irate and all of that, which again, he didn't know in this report, so 9 months later, why did he walk up to the police, walk around the individual that was trying to stop him from walking up to the police? Irate people, disruptive people, guess what they don't want to be? Involved with the police. Ladies and gentlemen, it's not complicated. It's not true. People have a burden beyond a reasonable doubt, and that means, are there questions that were not answered by the testimony that was presented? And they're wrong. You have not, they have not met their burden beyond a reasonable doubt. And you don't get to go to answer. You don't get to guess or surmise or do 3.9, so I guess it's a 4. No, because we already know it wasn't a public place. We already know there was no intentional endangerment of the safety of another or property, because I asked the officer, did you see it? Not what you heard, not what you were told. Did you see it? Did he present any of that to you? He did not. And therefore that fact is not evidence. Therefore the people can reach their burden beyond the reasonable doubt. And therefore Mr. Clark not him, but the child, disorderly person, in public intoxication. And I thank you for your attention. Thanks, President. Before people, I need to see council. Well, yeah. Mr. Flanagan, bring that, this print up.
Okay.
Okay. Any rebuttal by the people?
Yes, Your Honor. What's that?
I know this, still I keep on asking you to go back there and then not waiting for you to set it back up. Okay, thank
I proceed to-
you. You may.
So, ladies and gentlemen, my job here today is not to trick you all, or confuse you all as to what you all do. And based on the testimony from Officer Law, there was initial run to this address for a felonious assault. Officer Law came into contact, Officer Law came into contact with Mr. Clark. And upon his contact with Mr. Clark, he testified that he observed slurred speech and the conversation that went somewhere else that really with him. Now, ladies and gentlemen, you heard testimony from Officer Law that at this point he was fresh out of the academy, and that in the academy he was taught about these indicators and signs of somebody who's drinking here. Now, ladies and gentlemen, I don't want you to confuse this all with the operating while intoxicated cases. That's not what I'm here for today. I don't want you to get this all confused with the steps that an officer has to take when they come into contact with somebody who can operate while intoxicated. Okay? So that's not why we're here today. We're here because Officer Law was dispatched to his home, and when he arrived, he came into contact with Mr. Clark. And upon his observation of Mr. Clark, that's when he noticed Mr. Clark had been drinking with him. Upon his contact with Mr. Clark, he noticed these other individuals holding Mr. Clark back on the sidewalk by the vacant lot. Now, ladies and gentlemen, assuming that you all live in the city of Detroit, everyone knows that it may be a burden on us to maintain the sidewalk, but if you're a homeowner, you know that that sidewalk is not your property, it still belongs to the city. You may have to upkeep it, you may have to shovel the snow, you may have to make sure your taxpayer dollars go to repair that sidewalk, but it's not your sidewalk, right? It still belongs to the city. Now, ladies and gentlemen, there's something we refer to in law as the best evidence rule. And that rule states that a writing, recording, or a photograph has to be shown as the best evidence in the case, because that's what it is, the best evidence. And ladies and gentlemen, the people did show you video. And without me telling you all what was the video, because you all have eyes, you all take the video, I'm gonna ask you to look at this video one last time and use that common sense and everyday experience that you all have and that you all have in common in your everyday life to come to your own conclusion as to what Mr. Clark's position was, his disposition as someone officer law. And after seeing this video one last time before you go deliberate, ladies and gentlemen, the evidence that was presented to you, the best evidence that was presented to you, will all help you determine that Mr. Clark is guilty of count one, the serving person. Got a man say my speech? Right. Without the time. The people will stop that video at 3 minutes, 29 seconds. Again, ladies and gentlemen, thank you all for your time and thank you for serving us.
Ladies and gentlemen, I was trying my best to keep on word. I'm gonna give you an option. Okay, it's 4:44 and it is gonna take me at least 15 minutes to read the jury instruction. So my question to you is, do you want to break for today, or do you want to read these jury instructions? And I don't know how much time they're gonna give me in the building.
Go ahead.
Until they kick us out the building.
Yeah, we're the jury, they have to stand for us.
Okay, let's go, let me hurry up and read. All right.
No food.
Keep it going. Just keep going until they kick us out the building. All right. Or until the court reporter says I'm listening. You can say everything. All right, members of the jury, the evidence and arguments in the case are finished, and I will now instruct you on the law. That is, I will explain the law as it applies to this case. Remember that you have taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy or prejudice influence your decision. As jurors, you must decide what the facts of the case are. This is your job and nobody else's. You must think about all of the evidence and the testimony and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in the case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer has said something different about the law, follow what I say. At various times, I have already given you some instructions about the law. You must take all of my instructions together as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum it up, it is your job to decide what the facts of the case are, to apply the law as I give it to you, and in that way to decide the case. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of the case. Every defendant has the absolute right not to testify. When you decide the case, you must not consider the fact that he did not testify. It must not affect your verdict in any way. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of the witnesses, the exhibits admitted into evidence, and anything else I told you to consider. Many things are not evidence, and you must be careful not to consider them as such. I will now describe some things that are not evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. The lawyer's statements and arguments are not evidence. They are only meant to help you understand the evidence and each side's legal theories. The lawyer's questions to the witnesses are not evidence. You should not consider these questions. You should consider these questions only as they give meaning to the witness's answers. You should only accept things that the lawyers say that are supported by the evidence or by your own common sense and general knowledge. My comments, rulings, questions, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies to this case. However, when I make a comment or give an instruction, I am not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide the case, please pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I have excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all of the evidence, regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during the trial. As I said before, it is your job to decide what the facts of the case are. In deciding which testimony, you do not have to accept or reject everything a witness said. You are free to believe all, none, or a part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experiences. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have based on the race, gender, or national origin of the witness. There is no fixed set of rules for judging whether you believe a witness, but it may help for you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that may have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act when testifying? Did the witness seem to be making an honest effort to tell the truth, or did the witness seem to evade the questions or argue with the lawyers? Does the witness have any bias, prejudice, or personal interest in how the case is decided? Have there been any threats or promises, suggestions, or other influences that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the evidence in the case? Sometimes the testimony of different witnesses will not agree. Oh, that's not applicable. You may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. Facts can be proved by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that is direct evidence that it is raining. Facts can also be proven by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So for example, if you see a person come in from outside wearing a raincoat covered with small drops of water, that would be circumstantial evidence that it is raining. You may consider circumstantial evidence. You may consider circumstantial evidence by itself or a combination of circumstantial evidence and direct evidence can be used to prove the elements of a crime. In other words, you should consider all the evidence you believe. Her testimony from a witness that was a police officer. That testimony should be judged by the same standards that you use to evaluate the testimony of other witnesses. The prosecutor must prove beyond a reasonable doubt that water. Okay, thanks. The defendant is charged with the crime of being intoxicated in public and causing a disturbance or endangering persons or property. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant was in a place open to the public. Second, that the defendant was intoxicated. A person is intoxicated when he or she is mentally or physically impaired as a result of consuming an intoxicating substance, such as an alcoholic beverage or other substances. Third, that the defendant directly endangered the safety of another person or property, disrupted the peace and quiet of other persons, interfered with the ability of other persons to perform actions or duties permitted by law. The defendant is charged with disturbing the peace. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant was in a tavern, grocery store, business place, manufacturing establishment, street, lane, alley, or highway, or public building, at a park, an election, a public meeting where people were lawfully assembled. Second, that the defendant intentionally engaged in conduct that threatened public safety, threatened violence to other persons, disrupted the peace and quiet of other persons present, interfered with the ability of other persons to perform legal actions or duties. The defendant must have intentionally engaged in conduct that went beyond stating his position or opinion or the mere expression of ideas. The prosecutor must also prove beyond a reasonable doubt that the crime occurred on or about June 18, 2023, at or near 16546 Stokely Street in the city of Detroit within the county of Wayne. When you go to the jury room, you should first choose a foreperson. The foreperson should see to it that your discussions are carried on in a business-like manner and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communications equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agrees on that verdict. In the jury room, you will discuss the case among yourselves, but ultimately each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. It is your duty as jurors to talk to each other and make every reasonable effort to reach agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try to reach agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own and you must vote honestly and in good conscience. Possible penalties should not influence your decision. It is the duty of the judge to fix the penalty within the limits provided by law. If you want to communicate with me in the jury room, while you are in the jury room, please have your foreperson write a note, put it in an envelope, and give it to the court officer. It is not proper for you to talk directly to the judge, lawyers, court officers, or other people involved in the case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return a unanimous verdict, do not reveal this to anyone outside the jury room. That means if you're deliberating and your vote is tied, or, you can't reach agreement, just send a note saying we can't reach agreement. Don't send a note saying it's 3-2, or that don't add up to 6. Don't put the numbers in the note, just say we can't agree, okay? If you wanna view the exhibits, which it was only one, you're gonna have to come back in the courtroom, because I don't have a way of sending that video back to you. I am giving a copy of the instructions, and normally every juror will get their own book, but as I indicated earlier, Ms. Pillow is not my regular court reporter, and normally my court reporter would get the jury books together, so I'm only gonna send one book back. I tried to make sure that it was up to date. So I'll send that one back, and then you may return a verdict of guilty of the alleged counsel approach. I forgot to ask this question. All right, you may return a verdict of the alleged crime, or, I'm sorry, you may return a verdict of not guilty or guilty of the alleged crime, and the court is providing a verdict form. The only person that needs to fill out the verdict form is the foreperson. You're gonna date it, print your name, and sign it, and it just reads the case caption, and then we, the jury, by unanimous decision, find the defendant count 1 either not guilty or guilty of disorderly person wrong. All right. I am gonna pull 2 numbers. Okay, this is the way I do the alternates now. Due to since COVID came about, and plus other emergencies, I'm gonna pull 2 numbers. These individuals are going to be free to leave. However, if the jury does not reach a verdict today, we may have to call you. If the jury doesn't reach a verdict today and something happens to one of the jurors, the 2 that I'm calling, you're still alternate. You're still on call. We're gonna thank and excuse juror number 3. Please write your telephone number on the somewhere. Look, I'm sorry, y'all. I was looking at the jury's faces. They like, pull my number.
I was thinking you should ask the phone.
Somebody really needs to know. I can't do it that way. I can't ask for volunteers, can I? No, ma'am. Okay. And we're gonna thank and excuse juror number 1.
Oh. Thank you.
Ms. Ritter. Write your phone numbers down, please. All right, it's 5 o'clock. I don't know when they're gonna kick us out of the building, because I think I only got permission to stay till right now, but I'm gonna call upstairs. I'm gonna send you to the jury room, and then Officer Bennett, come on. Then I'm gonna see what they say. So just work until we're not gonna. Oh, juries.
All rise for the jury.
Oh, and then I know YouTube is mad at me because I had it on mute. And I didn't unmute, but, Mr. Clark, congratulations, he served, Miss, Taylor Coleman, please just fill out a dismissal form. I will sign the dismissal. And then, sir, you can wait in the hall for the dismissal. And then can the prosecutor and the OIC also step out? I'm just gonna talk to the jury briefly.
Do you have a fingerprint motion also, Your Honor?
Yeah, it should, the ones that you